Thank you.
Go back.
Gentleman's time has expired. The gentlelady from New York, Ms. Stefanik.
Thank you, Mr. Chairman. Secretary Walsh, during last year's hearing, I asked you why the Biden administration abruptly ended the Payroll Audit Independent Determination, or the PAID program, which was a successful compliance assistance program created under the Trump administration. And at the time, you said you were not familiar with this program at all. That's a quote. And that was very concerning to me, that as the Secretary of Labor, you were not aware of the decision of your own department to unwind this program. So after you've taken the time to learn about it, which I'm sure you have, I hope you've found, which are the facts, that the PAID program incentivized employers to proactively identify and fix any inadvertent payroll mistakes, getting workers 100% of the wages they earned faster than a traditional investigation would. This also allowed DOL to reach employers that typically were not prioritized for enforcement. This was a resounding success under the Trump administration. Millions of back pay, millions of back wages were paid, and this benefited tens of thousands of workers. So given this success, why did the administration end this program that helped employers comply with the law, a program that is a pro-worker program?
Thank you very much. I think last year when I was asked the question, I think I was about 6 weeks on the job. So it was, there was a lot that happened in the administration before I even got to be Secretary of Labor. But that's yesterday's news. Workers are certainly entitled to every single penny that they have earned. The last administration's Payroll Audit Independent Termination Program, after looking at it, we understood that it deprived workers of their rights to put employers that play by the rules at a disadvantage. And in January of 2021, obviously we ended the program, Wage and Hour. The division provides significant outreach and educational resources for employers seeking assistance to understand their responsibility to comply with the wage and hour laws. So we continue to work with businesses. And the U.S. Department of Labor is rigorously enforcing the law, and we will see that all the enforcement tools we have available. So we're going to continue to work with businesses on this.
Sure. I know that your argument is that it deprives workers of their rights, and that is simply not accurate. After an employer identifies back wages owed to employees through the PAID program, each individual employee has the choice to accept the back wages from the employer or to decline the settlement, and this preserves their private right of action. So the decision remains and is squarely in the hands of the worker. Moving on to worker classification, which is an important issue. Nearly 19 million Americans choose the freedom and flexibility of engaging in the modern economy as independent contractors. This is something that, as a new mom, many of my fellow new moms pursue this flexibility. They choose being their own boss over working as an employee for someone else. They choose when and how to provide their services, earning on their own terms instead of being told when to clock in and when to clock out. So my question is, why, Secretary Walsh, is the department targeting independent contractors and trying to take away that freedom and flexibility that are currently enjoyed by redefining employee status under the Fair Labor Standards Act? My frustration is that the administration doesn't believe Americans, they don't trust Americans to choose for themselves how to earn a living, and that bureaucrats in Washington should dictate how they work. I simply disagree with that, but I'm curious why the department is making that determination.
Because 19 million people don't choose to be independent contractors all across the board. Some of those folks are being forced into those different jobs, thinking that they were hired as employees, and then they get paid as with a 1099. And what we want to do is make sure workers that do choose to work as independent contractors have the protections they have, and workers that want to be employees should be treated as employees.
Sure. So to address the misclassification of workers, I would urge you to work with Congress to update the FLSA and insert the common law standard for worker classification that's used by most other federal agencies, bringing a clear and consistent set of rules across the federal government. I've legislatively been very active on that. I think it's very important that you know that Congress is working on this. Also, if you truly wanted to address this misclassification, we should leave the Trump administration rule in effect, as it provided clear rules of the road for workers and employees on what constitutes an employer-employee relationship and when a worker is an independent contractor. And I yield back the balance of my time.
Thank you. The gentlelady